Please proceed. We'll hear argument in 2354, CenterPoint Energy Resources against Ramirez.
May it please the court. Ms. Stokes will present argument for the petitioner. Petitioners have reserved 5 minutes for rebuttal. Ms. Thompson will present argument on behalf of the amicus. Ms. Stokes will open with the first 12 minutes and present the rebuttal.
May it please the court. The Court of Appeals did not dispute that plaintiff's injuries fall within the express scope of CenterPoint's tariff, limiting its liability for damages caused by gas escaping from the customer's house piping downstream of the meter. Nor did the court deny that these exact same limitation of liability provisions have been upheld as reasonable and enforceable as applied to negligence claims. The court nevertheless refused to apply these limitation of liability as written to the plaintiff's negligence claims here, based solely on its conclusions that Texas law prohibits applying limitation of liability to anyone other than the customer on the utility bill, and that the plaintiffs do not fall within the broad definition of customer in CenterPoint's tariff. Both of these holdings were error and require reversal and rendition of judgment for CenterPoint. The Court of Appeals held that regardless of the terms of the tariff here, as a matter of law, a tariff limitation liability can only bind paying customers. Now, the court acknowledged that this court has never stated such a rule, but it nevertheless relied on statements in several of this court's opinions that a tariff governs the utility's relationship with its customers. And indeed it does, but in all of those cases, there was an undisputed paying customer as the plaintiff, so the court had no occasion to and did not address the question of whether the tariff applies more broadly.
Are we looking at this tariff as a contract?
No, Your Honor, I believe based on this court's opinions in Ocean and Grant, which followed the U.S. Supreme Court's opinion in Western Union versus the Esteve Brothers, that held that a tariff is more than a mere contract, and by virtue of its approval by a regulatory body, it requires the force and effect of law. And the U.S. Supreme Court said that as any law, the contractual notions of assent are not relevant to applying the law to any person.
So that's your basis, or your response to the argument that in essence this would be binding a non-party to the tariff?
Yes, Your Honor, I believe that that's not applicable here when this court has said repeatedly that tariffs are by statutes and are interpreted as such.
Party that's applied a tariff to a non-customer as you interpret the tariff. I understand you have a broad interpretation of customer, and we'll talk about that. But beyond that, if you've got somebody who you wouldn't contend as a customer, but would still be given a tariff, what's the best case that is applied in that way?
So, Your Honor, I don't believe that there's a Texas case that has decided this issue, but there are cases from other jurisdictions that we cited in our brief, including the California Courts of Appeals, that have followed, like Texas, have followed the U.S. Supreme Court in treating a tariff as having force and effect of law by virtue of its regulatory approval and therefore binding non-customers under the definition of a customer as a purchaser.
If we adopt that, would you be able to include a provision in your tariff, for example, that says if a CenterPoint service vehicle hits somebody on the street, that they're not liable?
Your Honor, I've never seen a tariff that ever has at CenterPoint.
Right, but wouldn't that be the consequence of your argument?
Well, it would have to be approved by the regulatory body.
I understand, but is there a statute that authorizes them to approve a tariff that says that?
Well, so I think in that hypothetical, you would have an argument that it would be beyond the Railroad Commission's regulatory authority to approve something that has nothing to do with our provision of services, gas services.
Where would we look to find the limits of their authority to approve the tariff on certain?
The Gas Utility Regulatory Act. I mean, this court has said in the, its Ocean and Grant opinions were PURA, the Public Utility Regulatory Act and electricity, but the court said it's the authority to approve tariffs and limit liability comes from the broad grant of comprehensive regulatory authority to those agencies over the operations and services rates of the utility.
In Grant, we determined that a limitation of liability provision could apply to a personal injury claim, a negligence claim. And part of the analysis was that it was a reasonable limitation of liability and in part relied on the fact that ratepayers benefit from a limitation of liability provision, does that same reasonableness analysis apply when the injured party seeking relief from the utility is not a ratepayer and so doesn't benefit directly from a limitation of liability provision?
Your Honor, I submit that it does, and that all of the reasons or considerations, as this court called them in Grant, for upholding a limitation of liability as applied to personal injury apply equally regardless of the customer status of the plaintiff asserting damages. I mean, as this court knows, the reasons that this court stated, it says without a limitation of liability, the cost of substantial damages awards either threaten the financial integrity of the utility or must be passed on with regulatory approval to all ratepayers, and so it does affect the rate in that way regardless of who is the plaintiff suing. And the other reasons would be, it's still true when the plaintiff is not a customer that a utility has no ability through regulation to limit its exposure because it must take all comers. It must provide uniform, non-discriminating service to everyone. And as this court said in Ocean, regulated utilities cannot accurately estimate their exposure to damages or efficiently insure against risks in the context of equipment and premises that they don't own, control, or install. And that applies equally here if the plaintiff is not a paying customer of the utility.
You indicated in your brief that the drawing the line for a non-customer, it might not include anyone and everyone. For example, a person traveling through a downtown building, just happened to be in the lobby and something happens. But how do we draw the line if we take your view and draw the line broader to include a non-customer? How do you make that assessment whether someone qualifies and their liability and the utility's liability is limited versus someone who has no such limitation on their claim?
So to take your example of somebody walking through a building that I would presume would be heated by gas, I think under the tariff that person is utilizing gas services because it doesn't limit it to actively using them as opposed to passively. And I think the reasons behind the limitation of liability continue to apply in that context. But I don't think the court has to decide that today because they're applying our tariff to the plaintiff in this case, who undisputably was using gas services affirmatively in the Castillo house. So the court, I submit that would be a question for another day, but I do submit that the reasons this court laid out in its opinions would still apply.
We think of this as a contract. Would the plaintiff here be analogous somewhat to a third-party beneficiary who isn't a party to the contract, but is nevertheless bound to some extent by it?
I think if you look at it solely as a contract, you can make that argument, and indeed the tariff does say that the use of gas services means an agreement to abide by the tariff. Now, I think that's because the tariff has the effect of law that it recognizes that principle in the tariff. But yes, I think that they are using or benefiting from it and should be bound by the same limitation of liability. And again, all of the purposes behind the limitation of liability still obtain. And in our situation, this court said that a narrowly drawn limitation of liability that doesn't purport to relieve the utility of liability under all conceivable circumstances is reasonable, and that's the case here. There are exceptions for our negligence on our side of the meter, on our lines, and it would not apply to things like the car wreck example in Grant, and it still preserves the remedies at law that the plaintiff would have against all other responsible parties, the homeowner, in this case the builder and the licensed plumber who installed the lines and the valve, and whom the plaintiff did recover against. And I think if the court looked at the Intex versus Gonzalez decision, where they said that was a storing flammable vapors near an elevated gas water heater, but the court said it makes sense to the extent that anyone owes a duty that you shift the risks to persons like installers and salesmen and people who are in control of the house piping or appliances and in a position to ensure their safety, which CenterPoint with no
the definition of consumer, customer, or applicant is so broad that it seems to me it's difficult for me to think of a circumstance in which someone who might have a claim against the provider, the utility, would not qualify as a consumer, customer, or applicant.
Under our tariff,
They're all effectively using the gas. Otherwise, they wouldn't have a claim.
well, I think the tariff's definition of customer, if you're using gas, I can envision one scenario where somebody was walking by on the sidewalk and was affected by a gas explosion from the house, but wasn't using gas at the time. I think those would be somebody that wouldn't be covered by the definition in the tariff.
Or the car wreck with a service vehicle.
I'm sorry?
A car wreck with a service vehicle.
That's right, because it wouldn't relate to escaping gas, which is section 14 limitation liability, or the gas that's used downstream of the meter. I mean, our technician driving his truck to a scene who causes a wreck that the tariff would have absolutely no application to it. I will say the other point I wanted to make about the reasonableness of the tariff and the reasons that this court discussed in Grant, I mean, it was important that the limitations of liability are offset by the strict administrative review and control of the regulated utility. And that the court was talking about the PUC there, but the Railroad Commission has the same very broad powers to enforce its safety regulations and sua sponte, punish and correct unsafe practices. And so safety is regulated by the regulatory body entrusted by the legislature rather than through an ad hoc and potentially inconsistent jury awards. And so I think if the court reviews its decisions in motion on Grant, you can see that not once does the court talk about the reasons and the rationales depending on the identity of the injured party or the fact that the injured party is deemed to have a contractual relationship with the utility. Is there any more questions?
Any other questions? Thank you, Ms. Stokes. We'll hear from the state.
Thank you, Mr. Chief Justice. May it please the court, understanding that a utilities tariff requires setting aside the contract framework that the respondents ask the court to apply. Once that's done, it follows that the tariff's terms can bind non-customers when they interact with the utility. Going to Justice Boyd's question a few moments ago, I want to emphasize that the court does not need to agree with the petitioner's interpretation of consumer as it's defined in the tariff in order to apply these principles. Even if the plaintiff is not a consumer, if the terms of the tariff apply broadly and are not limited to consumers, then those terms are binding. And the reason for that is that the tariff is not a contract. On that note, I'll turn just very briefly to some hornbook law. A contract is binding because of agreement, but other sources of law don't require agreement to be binding. A statute requiring drivers to stop at red lights, that applies to me even if I don't agree to it, and even if I don't know about it. The same
Like that leads to potentially unlimited power in the Railroad Commission to change other law in the tariff with people who don't have any relationship with CenterPoint. Why shouldn't we be concerned about that?
Because the Railroad Commission only has delegated authority to regulate the gas services here.
Right, but it's very broad. I mean, services and operations, as we discussed in some cases last term, are quite broad terms, so it could touch anything that the utility does potentially.
So if the Railroad Commission were to approve a tariff with something like your Honor's hypothetical, then we would have to talk about whether that's within the Railroad Commission's authority. I don't think that it's a fair reading of the enabling statutes that give the Railroad Commission authority to say they can do just anything and everything. What we have here is something that is well within the heartland of a tariff and appropriate Railroad Commission authority. It makes sense for the court to explain, because the court has never had an occasion to address what a tariff is not a mere contract principle means for a case like this. So the court should clarify that the tariff stands on equal footing comporting with the regulation. It should be uncontroversial that Railroad Commission regulations are binding even to parties who don't agree to them. If they apply to you, they're binding on you. Now, of course, a lot of Railroad Commission regulations don't apply to people walking down the street. But here, the limitations on liability are quite broad. Section 14 and Section 17 itself is also pretty broad. It refers to all of the risks are assumed. And those terms would apply to the claims here.
In Western Union case, that is the genesis for a lot of these, for our cases. And the court said the limitation of liability was the lawful condition on which the telegram was sent. So, is there some idea that there's conditions of use that users have to meet and that utilities may impose for service that doesn't necessarily translate into similar conditions for non-users?
So there could be hypotheticals where a condition of use just doesn't have any application to non-users. For instance, the tariff, includes an obligation to report leaking gas. I think it's fair to say that, the mailman who's coming up to the door doesn't have an obligation to report leaking gas under the tariff or any kind of contractual arrangement. But when the conditions of use do apply more broadly and aren't cabin to someone who's a customer buying the gas services, then they can't apply more broadly, like any other regulation or statute.
Any other questions?
I just have one question. So you brought up the question that had to do with the red light, and you don't agree to stop at a red light. But isn't that just fundamentally different than this situation? Because in that situation, there can be a lot of different things that happen as a result of one or the other breaching whatever duty. But that's really not what we're talking about here, right? We're just talking about whether or not that third party who didn't enter into the agreement would be able to hold somebody else responsible for what happened as a result of any alleged negligence, right?
So if I understand our Honor's question, maybe a better comparison would be common law tort duties. We can start with first principles and recognize that, the common law of torts imposes duties on people. That includes property owners have a duty to invitees to make the premises safe, for example. This is similar in the sense that as a broader regulation, liability is limited. The legislature does that by statute all the time. Limitations on liability or caps on damages in the medical malpractice situation, for example. This is like that. By approving the tariff, the Railroad Commission has, in a sense, supplanted the common law of torts by approving these limitations of liability.
Any other questions? Thank you, Ms. Thompson. We'll hear from the respondent.
May it please the court. Mr. Mayo will present argument for the respondent.
Please the court, Mr. Chief Justice. I want to say as a kid from Sealy, Texas, it's a great honor to be here. I wanted to address a couple of the arguments that were made in the petitioner's argument. First of all, they're asking this court to be the first one to extend the tariff to a non-customer in a personal injury context that I'm aware of. And I will say that this issue was squarely addressed by the Indiana Supreme Court in the Titus case in December, and the Intermediate Court of Appeals opinion was affirmed in December 2020. And there's a statement made in CenterPoint's brief that was just an Intermediate Court opinion. It wasn't. There was oral argument on it. You can watch the video online, and they held consistent with our position here that you can't apply a tariff to a non-customer. As have all the other cases, including those cases in Texas, such as the Tulsi Water case, which was cited here, and the Henderson case. The Henderson case is incorporated into the Grant decision. So the law in the state of Texas is, or has been to this day, that you cannot bind a non-customer to a tariff. Now, a tariff does have the force of law in the the sense that the parties to it can't amend it, can't novate it, can't do the types of things you would ordinarily do with a contract. In other words, a utility can't discriminate in service with other customers, they can't negotiate special rates with customers. That's the sense that it's the full force of the law. It doesn't give the utility the right to legislate away your rights under municipal ordinances and tort duties that have existed for decades. And I would submit to you that under CenterPoint's proposal, any person is a CenterPoint customer. Anytime they step into a supermarket, anytime they step into a building, and that is beyond the scope of a tariff. And this.
But isn't that one reason a bright line rule is important? That one side of the meter, the responsibility is the utilities. The other side of the meter, the responsibility is not the utilities. And so, and because you can't control who the users are of the utilities product. The utility can't say, don't allow your overnight guests to use our hot water, from your gas heater.
Well, I am in favor of bright line rules, and I think you would go with the utility code's definition of consumer. And if CenterPoint wants to add other people to the bill, then they can do so. And whether or not they can bind children and things of that nature would be another case that you guys would have to consider at some point in time. As to the issue of the downstream versus upstream, the cases go back decades that require, and it's not in all instances, when you initiate gas service to a home, there is a duty to make sure that all the outlets are plugged. That has now been codified in the municipal ordinance in Laredo, but it dates back decades. You heard some discussion of the Intex versus Gonzalez case, which is the 14th Court of Appeals opinion from 2002, in which there was a water heater that was installed, wasn't put high enough up, and then years later somebody put a gas can next to it, and there was some type of fire and explosion. But that case specifically differentiated and cited in light of cases from the situation in which there's an appliance interfacing with a fuel source that's not coming from the utility versus a leaking or otherwise unsafe pipe connection or appliance on the basis that the latter could itself cause an explosion or fire if the gas was supplied to it. And in that regard, if you look at the Salazar case itself, the Salazar case specifically states it would appear to be the duty of the gas company to make some inquiry or investigation to satisfy itself that all openings in the house pipes are closed at the time it turns on the meters.
But doesn't that confuse the duty and the potential negligence flowing from that duty with the limitation of liability, which would only kick in if the utility was negligent in performing some kind of a duty on the other side of the meter?
I do. I believe there's two kind of notions going on there. One is who can you bind the tariff to, and then the second one, whether or not the tariff, even with regard to customers, can exonerate the utility from the negligence, right?
Right.
And I think in this case, by the way, you don't need to go there because this tariff has an exception for valid municipal ordinances, which CenterPoint has conceded. There was a valid municipal ordinance requiring them to inspect and focus stock consistent with the common law. And I'd like to cite for the case, if I may briefly, the Salazar case, and it incorporates the Ambrose versus Petrolane case. The Salazar case is 63 California Reporter 2nd 522, and the Ambrose versus Petrolane, which is this exact scenario, is 319 Pacific 2nd 1. And so,
if in this case, Mr. and Mrs. Castillo had been injured instead of Mr. Ramirez, we wouldn't be having to deal with the limitation of what it means to limit the limitation of liability to customers or consumers, but it would still be your position that that limitation of liability would not protect CenterPoint in this case if the Castillos were the plaintiffs.
That's correct, because of the exception for valid municipal ordinances that codify this very important rule that's existed for decades. And CenterPoint doesn't dispute that they go out there and it's very important for safety purposes for them to inspect and plug these valves. It's something that protects all of us. And that is that it is a narrow duty that is related to when you first turn on gas to a meter. And that is when it applies. It's when it's always applied and applied here. And when they negotiate, please finish. When negotiated this tariff with the city of Laredo, they incorporated in it that there would be an exception for valid municipal ordinances to include this one. And so therefore, we would argue, even in the case of the Castillos, that the tariff wouldn't apply here. However, we don't have to get there in this case because these folks weren't customers.
Or we don't have to get to the question of whether they were customers if we agree with that point.
That's correct.
And is the meter loop exception a separate independent reason why you think it doesn't matter?
Absolutely. And I think that's something that's been muddled a little bit. And I saw the drawing that was submitted yesterday, which wasn't evidence in the case. The actual evidence in the case came from the technician who testified, number one, that you do have to go inside the house to install the meter loop. That is in the report.
The non-liability provision, paragraph 17, does not limit liability for negligence of the company in maintaining its meter loop. And would you just flesh out briefly why that exception applies here, you think?
Right. And so the technician, which this was uncontroverted, we live and die with the record that was admitted as a trial court. And at this trial court, without objection, the technician testified unequivocally that this is on page 333 of the report. Do you actually have to go inside the home to build the meter? Yes. And then there's a series of additional questions, also in the fourth reporter's record. And this is on page 317 to 318. Part of doing a smart meter install and maintaining the meter loop would be checking all the gas outlets in the house to make sure they're plugged and sealed, right? Answer, yes, no objection. On page 318, part of maintaining the meter loop is making sure that all the valves inside these houses are plugged, right? Answer, yes, no objection. And you acknowledge that failing to check the valves in the Castillo home is part of the meter loop install and maintenance to ensure that the valves are plugged. And failing to do that would be a violation of CenterPoint's policy, right? Answer, yes. I mean, you can't have a properly maintained meter loop in a customer's house if it has open valves at the time of installation. Agree? Answer, yes. Again, no objection. There's more. We're going to talk about the importance of doing these inspections as part of the installation process. So yes.
Is that consistent with what a meter loop is, though? I mean, what's your understanding of what a meter loop actually is distinct from house piping and that sort of thing?
And I would make the distinction between the meter loop itself and the installation and maintenance of the meter loop.
And what is the loop? Let's start with that.
The meter loop itself, this wasn't evidence in the case. We have the record that's before us. But they take the position that the meter loop is the thing outside, right? And this individual that testified, the only evidence that's in this record is that part of maintaining the meter loop and installing it is making sure that there's not any unplugged valves. And that is consistent, by the way. It's not just that, that's consistent with the cases that we cited for Your Honor that set out this duty in the first place, that when you go into a house to install a meter, you have to check these valves. It's part of the installation and maintenance of the meter loop to do this, to go inside these homes and to check these valves. Now, this record, maybe there'll be another case where CenterPoint argues and has an expert or has testimony from its technician to the effect that the meter loop is something else and this is a part of the meter loop duty, but that is not the record that's before this court. And that is another independent, narrow basis to affirm it. And, I don't know what the court's position is on traditional minimalism and restraint in a small panel or whatever, but I think the ordinance and the meter loop are ways to affirm the trial court's judgment without reaching the broader issue of whether a non-customer can ever be bound to a tariff.
If we don't go there, is your success dependent upon us construing this as a contract?
No. Because I do think that there are elements of the tariff that are like a contract, but I do agree that the courts have held that it has the full force of law. But the regulation is that you're regulating the relationship between the customer or the consumer and the utility. And then there's a contract with the Railroad Commission as well as kind of what how the case laws come down. And so it is a contract. It's more than a normal contract because the parties can't change it. But I don't think you need to go there because there's no authority for the proposition in any case law that a regulatory body has the ability to take away, which this court just recognized recently in the Unquote case, the longstanding common law right to pursue claims for injuries that's been enshrined in the open courts provision of the Texas Constitution. And there's no suggestion that that has been somehow delegated from the legislature to the Railroad Commission, particularly for folks who don't even have a relationship with the utility. And it leads to absurd results. So the pizza guy, he's at the door, possibly so he can recover, but if he steps inside to get his tip, now he's a customer because he's enjoying the gas. It doesn't make any sense. How many times do your grandparents have to visit your house before they are now enjoying the gas enough to be a frequent visitor, which is the position they've taken as to what you need to decide here to make them a customer. And so I think the bright line rules that, look, a customer is what we all know what a customer is. It's somebody who wants gas service. And we start from the proposition that we don't limit the ability of Texans to recover under the open courts provision. And if certain people cede those rights away in exchange for lower utility rates, so be it. But the default is that you have your rights. And you should have to have, now we're under CenterPoint's position, we're no longer even required to have defined credit. Now it's just, you can have your rights ceded away without even knowing that there's gas in the home, without even knowing that it's CenterPoint gas, without any of that. Which, by the way, another point I would make, if you wanted to look for another narrow reason to decide this case, if you look at the definition of consumer, customer, applicant, in this particular tariff, there's words in there that say to CenterPoint energy index, right? Which suggests that if it was just anyone who used gas, there would be no reason for those words to be in there, right? It would just be anyone who wants to use gas as a customer. But if it has to be gas to CenterPoint energy index, that suggests again that there's a conscious choice, or at least awareness, on the part of the person that you're using CenterPoint gas and therefore can go presumably research whatever the tariff is and what you might be forfeiting if you got a home that has CenterPoint gas as opposed to propane or solar panels or whatever they might have, right? And so I think that's another narrow basis to decide this case. I do want to talk briefly about, we do have the Henderson case, which has been the law of the land for a long time. It's an intermediate court of opinion, appeals opinion, where the petition was denied by this court, and then it was subsequently cited favorably in the Grant case. And that case specifically held that a tariff doesn't apply to a non-customer. That was also held in Tulsi Water, although in candor to the court, I acknowledge that there was a petition granted in that case and then they settled. So, but both cases that are out there have come to the same conclusion in Texas that you cannot bind a non-customer to a tariff with the utility. And that's also consistent with all the cases from all the other states, at least in the personal injury context, in which there's some type of open courts type protection for personal injuries. And again, that was just reaffirmed by the Indiana Supreme Court in December of 2020. There's some discussion, some suggestion that there was a dispute about factually, and I know we're not doing factual sufficiency review, but I did want to at least mention the fact that there is certainly testimony and evidence in this case from which the jury could conclude that this fellow went inside the house and engaged in this inspection. There's evidence that the homeowner did not turn on the hot water heater and that the technician did. There's testimony about the lighting the cooktop, which the technician did. He was inside that house. And again, he testified on 333 of Reporter's Record 4 that you can't build a meter without going inside the house and doing the inspection. And as far as actual knowledge, the jury's entitled to draw inferences from the evidence, and they may very well conclude the most likely scenario, which is this fellow went inside this house and started doing his work. He was rushing. He had some Christmas, he had a certain number of jobs before the Christmas break. He forgot to put the valve or didn't have a valve unplugged on his truck, intended to come back and do it later and didn't do it. And it ultimately resulted in this explosion. And that's why we have a record that states plugged valve, because he intended to do it. He knew, he had actual knowledge that the valve wasn't plugged, but he didn't plug it.
Under your definition, as a technician, a repair person who comes in to repair a gas stove and turns on the gas in order to do his or her work and ends up being injured, is that a consumer or customer?
I think CenterPoint would argue that it is.
I know I'm asking under your construction, would he?
No, I mean, he wouldn't be the party.
For purposes of doing his job, he's utilizing the gas services, isn't he?
Certainly, but first, my position is that that's not what makes you a customer. Our position is that what makes you a customer is when you have a relationship with the utility, or a relationship that's been approved under this tariff. And the worker presumably wouldn't have that relationship.
So under your construction, who would qualify as a person who wants to utilize the services?
I think that's applicant. So, folks, there's some certain provisions in the tariff that relate to when you apply for gas, you have to supply certain information if it's requested. I think that's section 3. And that's one of the other bases.
You're affirmatively trying to become a paying customer, but you're not there yet.
Correct. So, and that's one of the bases that the Fourth Court of Appeals affirmed the decision, because if you define consumer as broadly as CenterPoint wants, there's parts of the tariff that make no sense. Can CenterPoint request more information of the Ramirez's? And as an applicant, under the consumer is the word that's used in section 3, unfortunately, it doesn't make any sense. And we also have, not just the tariff itself, but there's other utility code provisions that would make no sense if consumer was applied this broadly. We have the utility code 104.351. That's the one that defines the customer as the person in whose name the service is billed. And then we have 104.103, where the CenterPoint can email cutoff notices to the consumer while it's at the Ramirez's. And then you can request a meter inspection under Utilities Code 104.257 as a consumer. Can the Ramirez's request a meter inspection by CenterPoint because they go visit the house sometimes? Of course not. We would respectfully submit that we would respectfully submit that the court should exercise common sense and consistent with the case law, hold that these folks are customers. If you reach that issue, again, if you decided to affirm this case on a narrower basis, I think there are those as well. I have a minute and 30 seconds left. I don't know if there's any further questions I can endeavor to answer.
Any other questions? Thank you, Counsel. Start you have 5 minutes.
Justice Busby, you asked what the meter loop is, and as the American Gas Association said in their amicus brief, it's an old-fashioned industry term, but it's called a loop because it runs from the inlet side of the meter, where our gas comes in, to the outlet side of the meter, which is where the gas goes out to the customer's house piping. And Justice Boyd, you asked about the meter loop exception, and of course the Court of Appeals did not agree with that argument, and for good reason. Mr. Martinez, he did indeed testify about the meter loop, but he was talking about under CenterPoint's internal policies. At 5 Reporter's Record 65, he says, so when you go out to a house, what guidelines or what standards are you following? Answer, our company policies. And of course, he was not an expert, and he never once mentioned the tariff or the standard of care. He was talking about our internal policies, which this court has said in FFE Transportation Services versus Fulgham did not state a basis for liability. And of course, no matter what he said, I don't think you can read the meter loop exception to include a duty to inspect, because then it would create an internal inconsistency, because Section 5D of the tariff says that we don't have a duty to inspect the customer's house piping, only our own lines and meter. And then it would make the exception in 17B swallow the rule, because pretty much any time you had an accident on the customer side of the meter, you could say, well, if only you had adequately inspected, you could have prevented something that you didn't cause. But so I think none of those are tenable.
Is your position that CenterPoint can't have an undertaking that's broader than the tariff?
If the tariff applies, it limits its liability for negligent undertaking as well as, because that's
the tariff doesn't speak to undertaking specifically, I don't think, but if CenterPoint's policies could otherwise, there's some evidence that they could be interpreted as undertaking additional duties. Is your position that CenterPoint can't do that unless the tariff, if it's inconsistent with something in the tariff, as a matter of law?
If it had like a contract or conduct that purported to undertake.
Yeah, like the internal policies of checking that everything's blood.
Right, I think that's right. I mean, I think one, they'd be barred by the tariff, but they're also barred by this court's opinion in FAA transportation services, our policies, they don't say what we did in this context anyway. I mean, they're a general policy, so they don't show an undertaking in this particular case. Mr. Morrow also talked about a conflict with the ordinance, and this is another argument that was not adopted by the Court of Appeals, and that's because there is no conflict between 14 and 17, the limitation of liability provisions, and the ordinance. The ordinance does say that before turning on gas, you need to inspect and cap valves, but it says nothing about civil tort liability, and conversely, the limitations of liability say nothing about CenterPoint's obligation to comply with municipal ordinances vis-a-vis the city. And so I think for the reasons that the court stated in the Houston Court of Appeals stated in the comments, there's no conflict because they're talking about different things. And I would go further and say the ordinance is not the proper subject of negligence per se liability because it's not a criminal statute, and it would also purport to create a duty not known in common law to inspect the customer's house piping.
Who qualifies as a person who wants to utilize the services?
I think that would apply to like the applicant. If I picked up the phone and called CenterPoint and said I wanted gas, then I think because it says applicant, consumer, or customer are the same word.
But that really narrows the concept of what it means to utilize services. If to want to use it, you have to pick up the phone and apply to utilize services. That's a very narrow concept to utilize services, and yet you're saying the concept of utilize someone who actually does utilize services is a whole lot broader than that.
No, I understand your point, Your Honor. I mean, I think it would also apply to someone who actively uses gas services, as in this case, using the gas stovetop, using the water heater for the shower, but as well as and that would be someone who desires to use it and intends to use it, as opposed to the hypothetical somebody walking into a lobby.
Pizza delivery guy in a different position if he steps inside the house before it explodes.
Well, I think that, and Mr. Morrow talked about the absurdity of applying it to the pizza guy, but Your Honor, I believe that for limitations of liability, they can only serve their purpose if they apply more than just one person on the customer bill. This court said in Grant that limitations of liability enable a utility to provide effective, consistent, and non-discriminatory service. And if you take the hypothetical of say, a master meter for an apartment building where there's hundreds of people living in an apartment building, that's part of to lure you in, they say, we'll pay your utility bill. So there's only one meter, there's only one customer. And if there's a gas explosion in that building, the limitation of liability applies to a single person. And when that happens, you really undermine the Railroad Commission's carefully balanced regulatory scheme that takes into account the limitation of liability in setting the rate. Let's see if I have a little bit more time. About other jurisdictions, I think most of the ones that the Court of Appeals cited were talking about the tariff before it did not purport to apply to someone other than a purchasing customer. But I think the distinction for all of them is that none of them involve the same presumption of reasonableness of a tariff that Texas law applies. And in fact, two of them said that they strictly construed tariffs. So I don't think that those are guides for this court in this case.
Time is expired, Mr. Stoltz. Any other questions? Thank you. The case is submitted, and the court will take another brief recess.